Okay, hello everybody. Thank you for joining us in the latest edition of the Burkitt's webinar series. This is our summer update. I'll just take you onto a slide with our speakers. So my name is Patrick Cooney. I'm a partner in the construction and engineering team at Burkitt's, and your three speakers are on the slide there. I'll introduce their topics on a separate slide shortly, but it's the familiar format. The entire webinar is intended to last an hour, so we'll look to finish a little bit before the hour to allow some time for questions. So please do use the chat function to send in any questions you may have. Not going to give you the hard sell about Burkitt's, but just some information there on the screen about the firm. Hopefully we're familiar to you all now. We're a full service law firm with 7 offices across the country now and over 1,100 staff. I'll just take you onto a slide to introduce the topics for today. So Katrina is going to talk to you about AI in construction contracts. And then Iain is going to talk about contracts execution in the digital age. Is an emoji enough? And then Emma will take you through an update of recent cases in the construction and engineering field. The slides and the recording will be available to you all and distributed after the session in the usual way. So without further ado, I will hand over to Katrina, who's going to talk about AI.
Thank you, Patrick. AI has been referred to as the next frontier, and so in today's session, I wanted to explore exactly what AI is, identify some of its key benefits, explore how it can and is being used within construction contracts already, and highlight some of the key practical and legal issues to be aware of. Looking then firstly at what AI is, as per the Cambridge Dictionary definition, it's defined as software which is used to perform tasks or produce output previously thought to require human intelligence, especially by using machine learning to extrapolate from large collections of data. So how then does it work? While the specifics vary across different AI techniques, the core principle revolves around data. AI systems learn and improve their outputs through exposure to vast amounts of data, identifying patterns and relationships that we humans may miss. This learning process involves algorithms that guide the AI's decision and analysis. These algorithms are trained on labelled or unlabelled data to make predictions or categorise information, while certain subsets of AI use artificial neural networks with multiple layers to process that information, mimicking the structure and function of the human brain. AI can be categorised in several ways depending on the stages of development or the actions which are being performed. There are 4 stages of AI development commonly recognised, which I've listed here. The most prevalent of those is referred to as limited memory or limited mind AI. These systems can use memory to improve over time by being trained with new data, typically through artificial neural networks or other training models. Moving on then to consider some of the key benefits of AI. In publishing its playbook on AI for the construction industry last year, the Chartered Institute of Building acknowledged that the use of AI has the potential to revolutionise the sector and help SMEs compete on a more level playing field with their larger competitors. A report by the House of Lords in February last year indicates that most importantly, this revolution will not be at the expense of jobs, concluding that roles in the construction sector are among those least likely to be affected by the use of AI. So how can it help us? AI can automate workflows and processes or work independently and autonomously from a human team. It can eliminate manual errors in data processing, analytics, assembly and manufacturing, and other tasks through automation and algorithms that follow the same processes every single time. AI can also be used to perform repetitive tasks, freeing us to work on more higher impact problems. For example, it can automate processes like verifying documents or, and much to my relief, transcribing Teams meetings and phone calls. AI can process more information more quickly than a human, finding patterns and discovering relationships that we may miss. Although when it comes to accuracy, and those of you who have used the transcribe function in Teams will recognise that the accuracy when it comes to that is somewhat lacking. Finally, AI is not limited by time of day, the need for breaks, or other human encumbrances. When running in the cloud, AI and machine learning can be always on, continuously working on its assigned tasks. In this context, the Financial Times suggested that the use of AI has the potential to increase global GDP by 7%. Given that the construction sector is one of the least digitalised, the potential impact AI may have here is even greater than compared to our other more tech-savvy counterparts. In this context then, AI can and is being deployed to assist with construction contracts in a number of different ways. Firstly, AI is being used to score and rank tenders based on a number of factors, including a contractor's historical performance, safety records, and risk metrics derived from previous engagements, for example. Now, in practice, these tools are delivering measurable gains. Some UK contractors operating across public sectors have reported reducing subcontractor tender evaluation time by up to 40% when using AI in their procurement processes. Elsewhere, one construction firm in Poland was able to reduce their tender evaluation time down to 10 minutes through the use of AI. However, we would obviously urge caution here. The key point is that AI should not be left to make the final decision on scoring or evaluation criteria without human review. Over-reliance on AI could result in legal challenges if the public procurement evaluation process is perceived as being arbitrary or opaque. Other examples of the use of AI in a construction context include at the pre-design stage, where platforms such as BlockType are being used to demystify sites and undertake feasibility studies to determine if projects are viable. Furthermore, generative AI is being used to produce detailed design documents that help steer a project forward from initial conceptual design through detailed design development. For example, XCool, an architectural specific AI tool, was used to design and build the Shenzhen Bay International Hotel. I've added a picture of that to this slide here. Now, some people have referred to this hotel as looking like a hotel built by robots for robots, but I'll leave you to make your minds up on that one. Crucially, however, it's proof that AI can and is assisting with the whole process of design development, turning 2D images into 3D models and transposing lists of room sizes and daylight requirements into workable floor plans. These new tools and techniques are helping improve the quality and efficiency of the design development process, with the added benefit of improving the customer experience. Clients are able to review a range of different design options to determine what works best for their space, with the ability to input into those designs with different requirements and produce new iterations of designs and changes all in a matter of moments. From a construction contract perspective, again, AI is being utilised in a number of different ways. Firstly, when it comes to project documentation itself, programs such as natural language processing, or NLP, are being deployed to help analyse project requirements, creating detailed project scope documents from two-dimensional construction plans. They can also produce specifications by suggesting suitable materials and project matches, identifying when certain projects are incompatible with one another. They also have the ability to identify possible environmental gains by suggesting materials which are more environmentally friendly or would result in improved air quality, for example. They can also similarly assist with programming. Programming can be better maximised at the outset of a project, with AI being utilised to help optimise a programme of works based on data from previous projects. The use of AI in this context can allow contractors to optimise their resources on a site or across multiple sites thereby increasing efficiency of both labour and machinery. This allows or has the potential to allow for cost savings to ensure that time is best spent and machinery is not sat idly by. Additionally, by ensuring that works better remain on the critical path, there's then reduced exposure to liquidated damages. When it comes to the process of contract negotiation, AI is being used through systems such as Copilot or even ChatGPT. Furthermore, systems such as Luminance, Thought River or Document Crunch can review and summarise complex contracts, extract key obligations from those contracts, identify deadlines and other risks, and make suggestions on alternative drafting or rationale for contract negotiation. They can also compare contract clauses, new variations of contractual clauses against the original contract terms, automatically flagging any inconsistencies or anomalies. And finally, AI also allows for greater efficiency and efficacy when it comes to managing the contract itself. It can automatically monitor all contractual obligations, generate detailed summaries of those obligations and liabilities into a single document, and alert users to approaching deadlines. Additionally, AI is able to assess and alert users to differences and anomalies between different forms of contract, enabling users to better focus on the key requirements of particular sites and schemes. When it comes to litigation and dispute resolution, AI is now being used as part of the overarching litigation strategy. By analysing large volumes of adjudication data and case information, it's able to help predict potential outcomes with great success. For example, in a study by the American Society of Engineers, AI was able to predict outcomes with 95% accuracy compared to 62% by experienced reviewers. Looking then at adjudication, the Technology and Construction Court Solicitors Association recognises that AI and generative AI is here to stay and that its use will only exponentially increase in the future. TEXA recently reduced guidance, reminding its adjudicators that they remain personally responsible for their decisions, regardless of what tools are used in drafting and or legal research, whether that's generative AI or otherwise. Looking then at some contractual considerations, from a regulatory and industry context, the UK continues to take a principles approach to AI regulation. That means that there are no dedicated laws for AI in construction contracts as of yet, but guidance is nevertheless evolving. Government consultations on AI regulation continue to encourage businesses to act diligently, especially with respect to data protection, accountability and risk management. In particular, a procurement policy note from March 2024 urges public sector bodies to disclose when AI has been used in the tendering process and encourages those public sector bodies to carry out additional due diligence if bidders have relied on AI tools. It's therefore likely to be a question that you'll need to answer when it comes to tendering. There is an increasing recognition for the need of AI-specific clauses in construction contracts. Now, these might include risk allocation provisions that clearly define liability for errors caused by AI, such as AI hallucinations or misinterpretation of data. This will be particularly important as the use of AI increases, as so too will the risk of disputes which may arise from decisions made or missteps taken by those AI systems. Care should also be taken to ensure that parties do not upload confidential data and contract documents to third-party AI, and also that the use of AI is compliant with data protection legislation and other security protocols or confidentiality provisions of the contract itself. Finally, where AI produces original material in respect of which it is the author, users will need to ensure that they have the benefit of an appropriate copyright licence permitting use of that material and that that licence is freely assignable. Parties will need to review their contract documentation to ensure that copyright licences extend to material which has been generated by AI. Finally, some key takeaways. AI is clearly rapidly transforming the construction industry, including how contracts are evaluated, administered, and enforced, with the introduction of smart contracts only adding to that further. Regulators are catching up, and bodies like the RICS and the Chartered Institute of Building are issuing useful guidance that we all need to be alert to. However, legal and contractual clarity is essential. It remains the case that poorly drafted agreements could lead to increasing exposure to disputes. Ultimately, poor input of data at the outset will lead to poor output. Above all, human oversight is indispensable. Whilst AI is undoubtedly a powerful support tool, it's not a substitute for legal reasoning or professional judgment, or clearly highly skilled and trained professionals when it comes to designing and constructing buildings. Finally, I'll finish here with a quote from Sarita Jackson. The landscape of AI is rapidly evolving. We need to embrace it as the enabler that it is, paying careful attention to its risks and challenges, or get left behind. Construction law is on the cusp of a complete transformation. By approaching AI with clarity, caution, and contract precision, we can reap its benefits while protecting the legal integrity of construction projects in England and Wales. Now, for those of you who are interested, I've added a list of some further reading here. Thank you. I'll now hand you over to my colleague Iain Thom, who'll talk to you about contract execution in the digital age, raising the question of whether an emoji is enough.
Thank you, Katrina, and good morning, everybody. Thank you for taking the time out to listen this morning. And carrying on with the tech theme, I'm just going to have a look at one small part, I guess, of the impact of electronic usage that we see all around us today. So I'm going to look at the issues with regard to electronic contract formation, a quick look at the regulatory support for electronic signatures. There will be a certain amount of irony if you had your AI supported document and you had to print it out and then hard sign it, but that's another story. And then we have a couple of cases which have come along in the not too distant past, which are worthwhile considering as a comparison to the regulatory bits. And the objective is really just to have a look at the legal framework, what sits behind, how can we trust electronic signatures, and then just have a look at the current cases and distinguish those perhaps. So just to throw a net round what we're talking about, these are all forms of electronic contracts that we are used to. We start in the top left with click box agreements with the cursor hovering over the box that says, by clicking this box, I agree to the terms and conditions attached or referred to. The growth of organisations such as Amazon post-pandemic means that those boxes are something that we see probably every day. The stylus or touchscreen image is a bit closer to the old-fashioned wet signature thing, in the sense that you actually physically have to do something as a person to do to apply the signature. You've then got typed or inserted images, so the option to actually type your name in rather than having a wet signature or something that's more personalised. Web-based signature platforms elevate the whole point of electronic signature to a different level. The DocuSign platform that we at Burkitt's tend to use for completion of complicated contracts. Adobe Sign is another alternative, but DocuSign has a certification process that basically says if you use this process, you can rely on the certificate as evidence that the document has been properly executed. And then I'm just going to ping back to electronic exchanges, simply because that's the nature of the two cases that we're going to look at in a few slides' time. So moving on, why are we talking about this? What are the issues around it? Bottom left arrow, independence rules, cross-border acceptance. At the end of the day, there are still certain organisations, certain parties that won't accept an electronic signature. The Land Registry has particular rules for the use of filing of electronic documents that you have to follow. If you move outside of the UK and you're contracting overseas, you will definitely find jurisdictions that absolutely require wet signatures and hard copy documents to be delivered on the completion of an agreement as absolute proof of agreement and what you've signed, because essentially what we're querying is what is it that we're actually physically signing. We take away that security of the hard document and we rely on something that we can't touch, we can't see, when we go through the signature process. So the validity of the person signing, is it the right person? Do they have the authority? Is it just somebody in the office that's clicking a mouse in the hopes that that's going to be fine? Or are we actually contracting with the right person, giving the right sign off to the right terms? And the security of that, is it an open system? Is it actually the person that we think we're dealing with that is on the other end of the line when we sign the contract, however we do that? So there are issues surrounding this. What we have to help with that, there's been legislation for some time trying to address this part. There are the Electronic Communication Act, get my teeth back in. The Electronic Communication Act 2000, the Interpretation Act 1978, everyone had a go at it. And this isn't something that's particularly new, because if you look back through cases, things like the use of a rubber stamp to apply a signature have been the subject of case law. So this is just the next generation of tech that's saying, what is it that you have to do to mean that that signature is effective? So what we have probably is the highlight of the regulations at the moment is the snappily titled Electronic Identification and Trust Services Regulations, which I always have to read because I can never remember, which is an EU regulation passed in 2014 and is abbreviated to IDAS. Its purpose is to provide a secure platform for the understanding and the acceptance of electronic signature across member states. So if you follow the guidance that IDAS gives you, then anywhere in the EU, an electronic signature is considered to be equivalent to a handwritten signature. For those of you that are going, well, that's 2014 and we're no longer in the EU now, how does that help us? When we left as part of the exit legislation, IDAS was incorporated into the UK law. It was then updated to get rid of some of the bits that were obviously irrelevant because we were no longer EU member states, but effectively the EU IDAS still applies. And it does mean that we can contract electronically throughout Europe in the knowledge that it's secure following that guidance. I put part of the definition in the second bullet point there. And it is only part of the definition, but just the wording gives you an idea of how broadly they're thinking about in relation to this particular issue as to what is a signature. And it talks about data in an electronic form which is attached or logically associated with other data in electronic form and which is used by the signatory to sign. I imagine there was a group of incredibly clever people sitting in a room for quite a long time to come up with that, because it is a really broad definition. As you read more of IDAS, and there is much more of it, it does flesh out where you go from that, but it does obviously show you the problem that exists in relation to can you rely on the electronic signature on a document. So there we go. What am I saying in all of that? That electronic signatures are a thing that we need to rely on, we have to rely on, we do rely on. I can't remember the last time that I personally signed a hard document. I put them in front of other people to sign, but electronic contracts are everywhere, and there is regulatory support and reliance to ensure that we know that we can consider an electronic signature to be good. So, okay, moving on. As a comparison to that, we've got a couple of cases which have come up in the relatively recent past, which perhaps don't go quite so much to the execution of a contract, but they certainly go to the electronic formation of contracts. The first one is not a UK case. It comes from the High Court in the King's Bench Division in Saskatchewan, and it's Southwest Terminals against Acta Land and Cattle Limited, and it's to do with a flax contract. So SWT is a company that buys grain, and a gentleman called Kent Mickleborough at SWT put a communication out to potential sellers to say, give me your best price for flax. Mr. Acta called, they had a conversation, and they agreed a price of $17 a bushel. Mr. Mickleborough, bless him, went away, prepared a proper hard copy contract. He wet signed it. He took a photograph of it, and he emailed it, or he texted it to Chris Acta and saying, please confirm the flax contract. The response from Mr. Acta was that. It was an emoji, a thumbs up emoji, and that was it. So the question was, is that good enough? As events unfolded, ACTA was supposed to, in accordance with the contract, deliver the flax in November. They didn't. The original price was $17 a bushel. It was by November $41 a bushel. So clearly SWT not particularly happy. There had been a course of dealing between SWT and ACTA over the years, and Chris ACTA had tended to, in receipt of the similar communications from Kent Mickleborough, go, yeah, it looks good, okay, and yup. So he'd written words, he'd actually typed something in rather than just using an emoji. But the course of dealing was that they had upheld these contracts, they'd honoured them, and the court looked at this. It looked at the exchanges. There was no question of the exchange of messages, but ACTA was saying no. The thumbs up emoji was simply acknowledging receipt of the contract. It wasn't agreeing to it. The court had a look at the ordinary definition of what an emoji, what a thumbs up emoji was, and they said no. There's a contract. We're gonna allow that to stand. So that's quite significant. I guess my reaction to that was, well, it's, you know, it raises some eyebrows and it's a bit of a chuckle because it doesn't affect us directly because it's not a UK decision. And then we come to the next one, which is more recent and it's very much on all fours. JV Homes Limited against Fincham, or Steve Fincham, trading as Fincham Demolition. And this is very close to home from where I'm sitting in the sense that it related to demolition works of an old nightclub in Norwich, the old Mercy nightclub. So Steve Fincham had been to have a look at the site at the request of JV to price for some demolition works. He and a number of other people had offered prices, and Ben James of JV Homes was the man that was going to say yay or nay to whichever price won the day. So we have this exchange by WhatsApp on the 17th of May between Steve Fincham and Ben James, where Steve is clearly pressing on for the work. He's going, how'd you get on, mate? Is the job mine, mate? Ben James replies, can you start Monday? There's a discussion where Steve says, well, I can't do Monday, I can do the Monday after. We need the scaffolders to sort some stuff out. And pressing on, Steve goes, are we saying it's my job, mate, so I can get a start getting organised, mate? Simple reply from Ben James, yes. He follows up in a few seconds going, monthly applications, and that's it. There's a little bit of conversation after that, but essentially that exchange on the 17th of May is taken from the court extract as to what they looked at when they were considering the questions on this. As an aside, it's not an aside, but it's out of that particular exchange. On the 26th of May, so a week later, a formal purchase order and formal subcontract was emailed to Steve Fincham. And despite that, the court held that exchange of emails, in particular those two, are we saying it's my job, mate, and yes, constituted a contract. Now, the court hearing, what actually happened was Fincham did start the works, the scaffolders did sort stuff out, his men were on site as he suggested. He then started issuing payment applications, and quite a few of them, and there was a toing and froing between the parties as to what that should be. In the end, there was an adjudication chasing payment. The adjudicator found for Steve Fincham. There was a court application to enforce the adjudication. And then eventually, JV took the matter to the High Court and asked for a declaration as to what has gone on and the standing. What they were basically saying is, well, we don't think there's a contract as of the 17th of May. We think our terms apply, and in any event, whichever way you go, those payment applications are invalid, so we shouldn't have to pay them. And they also specifically said, well, there wasn't a meeting of the minds in the exchange on the 17th. There were terms that were outstanding. There was no start date. There was no start and end date. There was no period for the works. And the payment provision clearly was something that had been a cause of concern. What the judge did when he looked at this was he basically went, well, no. He said, as far as the start date is concerned, it's not fatal. You can do without that. And in any event, Fincham had actually done as he said. In terms of the length of the contract, the duration of the works, he said again, not fatal. You can do that within a reasonable time. It doesn't affect the application of the contract. And in relation to the payment terms argument, what he did was he looked at the Construction Act, the Housing Grants Construction Regeneration Act, and said you can effectively use the terms in that to supplement any outstanding or any necessary provisions to get a fully fledged contract. So that was that. That's a very simple contract exchange on the 17th of May saying, is the job mine, mate? Yes, was held to be a binding and enforceable contract. End of story. There were discussions in the background, and part of the argument by JV was that you wouldn't expect a £250,000 contract to be concluded in this way, and it must have been within the contemplation of the parties, certainly with Steve Fincham, that he would have had to have signed a proper form of contract, hence the follow-up order. But again, the court rejected that suggestion. So there we go, a salutary lesson. And the takeaways that I put from this is that there is significant regulatory support for the use of electronic signatures, and that presupposes that you've had a proper exchange in relation to the negotiation of terms, and a sophisticated contract is sitting there waiting to be signed. All of your negotiations have perhaps been without subject to contract, which still has a place electronically or handwritten. But you need to be aware that in the background, the communications that we have on a daily basis by the use of all of the platforms that are available to us to help with business can lead to a legal ramification. Certainly the JV case is saying you can contract for a demolition contract at £250,000 by WhatsApp, and it doesn't matter what else. So best to be clear. If in doubt, take a breath. If some side negotiations are getting a bit out of hand, bring them back into the main negotiations. Make sure they're all subject to contract. Make sure all of the terms that you want are in a document, whether it's electronic or hard copy, depending how you want to work, and then get it signed in a way that is unequivocal. There's plenty of guidance on that. It's easily done. We have all of the benefits of, the speed of transaction, the speed of usage of these systems, and that we can rely on them. So just be careful not to go around the outside of this. And that's me done now. So I will now hand over to my colleague Emma for a case update. Thank you.
Thank you, Iain. Thank you all. I'm going to be talking us through 3 cases today. So there's going to be one on instructing experts and without prejudice privilege. There's going to be another giving further information regarding the first building liability order decision, and one particular Supreme Court decision which is very recent and which has significant ramifications for the industry. So looking at the case of BNP Paribas and Briggs and Forrester first, the key issue was whether or not without prejudice privilege applies to third-party reports that were commissioned unilaterally by a party during a settlement discussion. So the background to this dispute was a scheme of replacement stair pressurization systems in a 30-storey office block, and there was a need to remove unforeseen asbestos, which caused the parties to fall out, and the need for a report on the presence of asbestos, which was obtained by BNP. During settlement negotiations, which were at that point ongoing, but what they didn't do was agree with Briggs and Forrester that report was being obtained and would be protected by without prejudice privilege. So this judgment has actually only been recently released because of confidentiality that attached to it. And the previous authority was from 1954, a case called Rabin versus Mendoza, and that confirmed that without prejudice privilege applied to third-party communications that were part of the parties' joint efforts to settle. So essentially, those third-party communications are deemed to be part of the parties without prejudice, or without prejudice saves to costs communications between them. So the outcome of this case was that the reports were actually not privileged, and they needed to be disclosed in the litigation such that the defendant could rely on them on an open basis at the trial. So it does reinforce the need for mutuality when obtaining reports that you intend to rely on a without prejudice basis only. Don't go off and take unilateral steps to get expert advice or without consulting your solicitors and without agreeing with the other side that that report's going to be protected by without prejudice privilege. Otherwise, you could end up needing to disclose it in open court. So always be cautious, and if in doubt, the route is to always instruct an expert to provide a confidential advice note by solicitors. So the next case we're going to look at is further detail of the building liability order that was made towards the end of last year. So the judgment was made ex tempore, so orally, and the transcripts only recently become available. The context is that the leaseholders were seeking to recover costs for structural and fire safety defects in a residential block. Developer was insolvent and they were seeking a building liability order against its parent company. And the key issue before the court was whether or not that was an associated company, whether a liability could be imposed on it, despite the fact that the parent company had limited assets and despite the fact that the parent company hadn't been named on the original pleadings. The court also had to consider the wording just and equitable. Is it just and equitable to impose a liability on that parent company? Now, by way of background, there had been a previous judgment between the parties to the effect that only fire and structural defects in this building were relevant liabilities arising from a building safety risk. So water ingress defects in the same building had nothing to do with the risk of with risks to the safety of people in or about the building arising from the spread of fire or structural failure. So the building liability order procedure was therefore only appropriate for the fire and structural defects. So what did the court find? As we know, they granted the building liability order and they found that the parent company was associated with the developer, which was a special purpose vehicle. So it's part of a long line, really, of cases where the courts are grappling with this idea of whether it's just and equitable to impose a building liability order, because this essentially pierces the corporate veil, which is a long-standing part of English law and the basis on which many developments have been made over time. So the court was considering whether it was just and equitable, and it found that it was, because essentially this case fell squarely within the intentions of the Building Safety Act, in that the special purpose vehicle was thinly capitalised, it was dependent on intergroup loans, but it did have the same directing mind. It was argued that the building liability order wasn't appropriate because the parent company didn't have significant assets either, but that was found to be irrelevant. So it was the special purpose vehicle's finances that were key. The parent also didn't need to be identified or joined into the litigation before a building liability order could be made against it, which is really a procedural point, bearing in mind that the process of seeking a building liability order is fairly new, and practitioners are still trying to work out the best way to go about it. Moving on to the case of URS and BDW. This was a Supreme Court decision. It has huge ramifications for the industry. It's very recent, it's only 3 weeks ago. So notably, BDW is a significant developer. They include brands like Barratt and David Wilson Homes. To put it in context, the developer was seeking to recover costs from its engineers for remediation works required due to structural engineering defects within a couple of high-rise buildings, and they were some serious safety risks. Now, The remediation itself was carried out in 2020 and 2021, and the claim was issued in March 2020. So at the time of issue, claims against BDW under contract and under the Defective Premises Act were actually time barred, and it wasn't until June 2022 when the Building Safety Act came in and retrospectively extended the limitation period that applies to claims under the Defective Premises Act for failure to provide a habitable dwelling. That was extended from 6 to 30 years retrospectively. So as a result of that, the pleadings were amended to include those Defective Premises Act claims and also to seek a contribution from BDW under the Civil Liability Contribution Act 1978. The court was looking on the appeal at 4 grounds, really, raised by the engineers in defence of the claim. The first ground was whether or not the remediation costs were voluntarily incurred and therefore recoverable in the tort of negligence. The second was whether or not the 30-year limitation period under the Building Safety Act also apply to the negligence and contribution claims against the engineers that were contingent on the Defective Premises Act claim. The third was whether the developer was owed a duty under the Defective Premises Act, or were duties only owed to the purchasers of dwellings? And the third was whether or not BDW could claim a contribution when there wasn't a third-party claim or settlement against it at the time of the remedial works. So it was found essentially that the losses were not too remote or outside the scope of the engineer's duty of care. The idea that voluntarily incurred remediation costs would bar recovery was dismissed. The court did mention that it potentially could be relevant to the separate legal issues of causation and mitigation, but only if the conduct in carrying out those works was unreasonable. On the second ground, it was found that the 30-year limitation period under the BSA applies retrospectively to claims that are dependent on the Defective Premises Act, not just to claims under the Defective Premises Act. So that included claims for negligence and contribution, as in this case. It was found likewise that the engineers owed a duty to developers because the developer ordered the work. So there was quite a detailed review of the wording of the Defective Premises Act in that regard, and it was found that developers are included within that category of party that's owed a duty. So it didn't matter that, they could have both owe duties to residents and also be owed duties by their contractors and designers. So the fourth point, potentially actually the most significant point about this case, is that the developer could claim contribution despite the fact that when it did those works there was no third-party claim against it to remediate. So its remedial works were found to be a compensatory payment in kind, essentially. So really it's sufficient for the purposes of a contribution claim now that the claimant has paid compensation, including in kind, such as remedial works for the same damage. Some key takeaways really about the significance of this case. Of course, it affirms developers' rights to recover costs for proactive remediation of buildings, and it clarifies the duties under the Defective Premises Act and extending the duration of numerous and various liabilities even where no third-party claims have been made, and it's likely to have an impact on insurance. So developers can seek contribution from contractors and designers without there being any third-party claim against the developer or any settlement having been agreed by the developer. Developers are also owed duties under the Defective Premises Act. Extended limitations periods that apply to Defective Premises Act claims are extended to related claims in the tort of negligence and for contributions. So the court really has removed some pretty significant procedural and legal hurdles here that had previously complicated recovery routes, and it facilitates a developer's related claims and ability to get to some funding to be able to perform its obligations to the homeowners. And I think possibly to do otherwise would have created a split legal regime and incoherence, potentially penalising responsible developers that have gone out and carried out these repairs. So what can people do to, in light of this case? I think really it flags the vital task of maintaining robust records for a long period of time, reviewing past liabilities and checking that the insurance covers that you've got in place are adequate. So now that concludes my talk on recent case law, and we're going to our Q&A session now. My colleagues are just joining me.
Okay, thank you to all of our speakers. We've had a few questions in during their presentations, and we've also had a few in advance as well. So we'll see how many of those we can cover in the time available. So question in around legal fees. Katrina, you talked us through AI. Does that mean we'll see legal fees for contract preparation and dispute resolution? Well, I'm not sure I'm comfortable with this question. Being reduced when the benefits of AI are used?
Well, I think we'll have to talk to Steph about fees, won't we, Patrick, from that perspective. But I think at the moment it's very much a support tool and function. As I mentioned in my talk, it doesn't replace the human touch or human oversight. And from a lawyer's perspective, and I know I would say that, wouldn't I? But I think, much of what we do is about adding value, understanding the client's business and their drivers around contract negotiation, what they're doing, their position in relation to disputes and litigation, etc. And you just don't have that personal function from AI tools. But no doubt, as processes become more sophisticated, etc., then there would be sort of some savings potentially in the future, depending on how the AI processes go.
Yeah, quite. I think that's right, Katrina. We're just not quite there yet, and this principle is going to be relevant to, I suppose, any fees, whether they be architectural or engineers' fees, any kind of professional fees in our industry, or anything which is based on human time being incurred, are all going to be affected by the same principle. But we're just not there yet. I mean, AI still requires a lot of human checking, because it also reveals a lot of potential dangers at the moment, given the stage it's at. It feels like it's a wave which is about to come sort of with huge benefit, but it's a sort of slightly dangerous time where it could be over relied upon. And that sort of links into another question we had in around, do we have any comments on the recent High Court series of cases around the misuse of AI, and a very junior barrister being reprimanded for relying on AI, which generated cases which didn't exist. So there's a very real example of over-reliance on technology and the dangers it can bring. So it comes back to the point that, not quite there yet. So we don't all need to go and hand our notices in tomorrow, everybody on this webinar, and become software engineers. We're not quite at that stage. And this is not new. Even when Google became mainstream, there were similar cases around. It may not have been AI generating false parties and false cases. It wasn't that sophisticated, but there were still similar cases around the dangers of overuse of technology. It was probably more students than practitioners back then, but there were cases of students relying on case law, which did exist, but not in England. It was relying on a case, on a principle which was relevant, but it was a Canadian case or a US case. So again, very much at a point where we can't over rely on it.
No, I think just quickly, Patrick, touching on the case, I think one was from Friday, and it related to a £90 million dispute, financial dispute with a bank regarding some security documentation. And AI was used in drafting witness statements and also in support of legal arguments, generating 18 separate cases that, as you said, didn't exist. And from a personal perspective, obviously that raises huge dangers, as the text of guidance said, in relation to adjudicators remaining personally responsible for their decisions. Equally, as lawyers, we remain responsible for the advice that we're given, and the firm. And so the lawyer in that instance, they had potentially exposed themselves to contempt of court proceedings. Obviously that's one thing. Thankfully, the judge in that case said that they hadn't quite met the bar for contempt of court proceedings, but nevertheless, they will be referred to the SRA. And the previous case that you mentioned, that was one in relation to a housing dispute with a local council, that junior barrister has been referred to the Bar Association. So not only are there huge risks in terms of how the litigation or the dispute itself goes, but from a personal perspective, it exposes us to great risks in terms of our advice and the profession and the career moving forward. And obviously that will apply equally to all of the other professions that are using AI, where you are required to provide your skill, your experience, your judgment, your expertise to deliver those consultancy services.
Yes, quite. In 5 or 10 years, we might be having a very different conversation, but we're not quite there yet. Okay, thank you. We had a question around signature. So, Iain, would you be able to comment on this one? There are a number of secure electronic signing tools, but is it also possible to place a scanned signature into a PDF contract? Is that acceptable from a legal perspective?
I'm going to give a classic lawyer's answer to that. It might be. If you look at the IDAS definition that was up on one of my slides, which talks about data in electronic form attached to or logically associated with other electronic data, then you kind of go, well, okay, the scanned signature is electronic data, the document is electronic, you put the two together and that's fine. The problem is that one of validity, isn't it? In the sense, it's not so much how you've done it, it's how it's been done. Is the person that's applying the scanned signature the right person? If I'm signing and I'm going to my contracting party, look, the easiest way I can do this is to scan my signature and put it on your PDF. Is that okay? Fine. If it's somebody that goes, oh, the boss is out, I've got a copy of his scanned signature, I'm pretty sure he would want that signed, I'm going to do it, and hey, that'll be fine. That's less good, isn't it? So it's, I mean, this is the question mark around electronic execution. It might be fine. Sorry, I know I'm hedging myself, but if in doubt, scan signatures are quite a dangerous thing to have lying around the office, because anybody can use them, and you can find yourself being bound to something that, because it's gone to one person and then it's been shared around the office, all of a sudden you've got 15 contracts you didn't know anything about. So possibly, but big note of caution on that process.
Yeah, absolutely. And a related question on your topic, Iain. In terms of the Fincham case, what happened to the battle of forms that we often hear about in that case?
Right, it was raised. So the battle of the forms is a good old legal seesaw, which basically means that the last person standing, or the last person to make a play, their terms prevail. So the suggestion was by JB, well, you might have had the exchange on the 17th of May, but we sent you over a fully drafted contract on the 26th. You didn't say anything about it. The judge took a very simplistic view to that. He said, well, okay, there was an offer and an acceptance in the exchange on the 17th of May. That concluded the contract. There is no need to go anywhere else to look at the terms. So basically, that particular email with the subcontract form missed the boat. I think actually that's probably one of the most salutary lessons that comes out of that case, because I think we all go, oh well, okay, if we sent our T's and C's over, that's fine. That's the last document there, they must prevail. But clearly not necessarily the case. And it's commonplace, isn't it, in construction matters that quite often the works start before the paperwork is signed. So if you want the sophistication of all the terms that you paid your lawyers to negotiate, the ideal counsel from us would be don't start before you've had it signed and had it signed properly.
Very good, thank you, Iain. Katrina, one more on AI. This is generating a lot of discussion. We talked about some of the limitations and risks of AI, but specifically, in the sphere of safety, how could AI be used to assist in that sphere?
Thank you, Patrick. Well, I think it can help enhance safety in a number of ways. So obviously, the use of real-time AI-powered cameras and sensors can help detect unsafe behaviours on site. So, for example, if someone isn't wearing their PPE equipment or entering restricted zones, and obviously it will alert people to that. It can also help analyse past data to help identify, situations where safety incidents may arise again in the future, and so help you to take preventative action to stop those incidents happening again. Obviously, you can make sure that people on site are wearing smart helmets and vests to monitor their environmental conditions, alerting them to potential hazards, etc. But just more generally, it can help sort of streamline that safety audit process, incident reporting, just to make that whole process much quicker, efficient and smarter, and identify sort of any non-compliance breaches during that process, which, as I say in my notes, that we might miss.
Very good, thank you, Katrina. It's 13:27. Maybe time for one more question. Emma, some thoughts on the BDW case that you mentioned. I mean, is it fair? Does it strike a fair balance, would you say?
Well, overall, I'd suggest it certainly seeks to strike a fair balance. It's also policy driven because it accords with the purpose and policy of both the Building Safety Act and the Contribution Act. It doesn't go as far as you might be concerned that it does, because one, is unlikely to be of much benefit to extend the limitation period for claims in tort if there's a defective Premises Act claim by the developer in any event, because those two claims would simply run alongside each other. And the extension to the limitation period is not retrospective for all purposes, and it doesn't change historical facts. And you don't need to match effectively defective Premises Act limitation periods in tort if those defects don't render the building unfit for habitation. I think potentially the most significant point about this case is the extension to the Contribution Act and the removal of lots of hurdles to recovering pursuant to that legislation. That said, the reasonableness of carrying out repair works on a voluntary basis will be applied, and it will be assessed at the time those works were carried out. But the court has indicated that if it's a serious safety defect, it's unlikely that they will consider that those works were unreasonable.
Absolutely, thank you, Emma. Okay, well, we've finished sort of bang on time, maybe even 30 seconds early. You might gain back to your day. So the recording and transcript will be distributed along with the slides. So thank you all for joining us today. We will be in touch with details of our next quarterly webinar, which will be circa 3 months' time, if we haven't all been replaced by AI by then. And if you have any topics sort of ahead of that next session, please let us know in advance. And thank you for joining us.